Hello, I'm Ashley Wiltshire of the Nashville Bar. This is February the 8th, 2022. We're in the office of the Nashville Bar Association to interview David Tarpley for the Nashville Bar Oral History Project. David is a friend of mine and former colleague as a lawyer at the Legal Aid Society. And he has the special distinction of having been first at Legal Services of Nashville, as it was known then, and more lately the Legal Aid Society for more than 52 years. A record that is most certainly never will be equaled. So it's a special privilege to be here with David. We're going to talk about some of his most significant cases over these last 52 years. But first, some of his interesting personal background. So David, please state for the record your full name, please.
David James Tarpley.
And their date and place of your birth.
August 15, 1946, Chickasha, Oklahoma.
Okay. Now, a few details about your family background, if you will, starting with where your mother was born and why there.
Well, I was a baby boomer and my mother was a war bride. She was British. She was born in Baghdad, Iraq, of British parents in 1920. They were there because her father, once he came out of the army at the end of World War I, went to work for the new British Mandate government of Iraq as an engineer helping develop the original Iraqi oil fields in the 1920s. And my mother was born, as she liked to say it, on the banks of the Tigris River in the British cantonment in June of 1920. The family lived there in Iraq until 1931, when the Mandate government came to an end and Iraq gained its independence. And the family came back to Britain to live, although my grandfather stayed on for another year or two working in Iraq.
Then what did your mother do as she finished school?
My mother was 19 when World War II began in Europe. That, of course, was 1939. And she had just acquired what was called a teaching certificate, which was a 2-year program, and entitled her to teach primary school children. And as the war began, she took a job in London teaching primary school children in the East End of London, where the docks were, which soon became the main target of the Blitz, the bombing by the Germans. After a while, she, along with most other teachers and their students, were evacuated out of London for the students' safety to wherever in England they could place them. And my mother's class and she were moved to a small town in Devon, which is in southwest England, a little town called Totnes. And it was in Totnes that she was teaching when my father's battalion, Army.
Your father was from Oklahoma.
He was from Oklahoma. He enlisted in 1942. And in 1944, his battalion, he was a combat engineer. And his engineer battalion arrived in Devon and was stationed in and near Totnes. Well, after the battalion got settled in, the school that my mother was teaching in decided that they would give a dance for the battalion. Well, my mother had a friend, and she and the friend went and helped set up for the dance. And my dad was at the time the company first sergeant, and he and the company captain went together to the dance. They walked in and they looked around, and the captain pulled rank and told my dad, I'm going to dance with this one and you dance that one. Well, that one turned out eventually to be my mother.
Yeah.
After a wartime courtship of 6 weeks, roughly. They were married in what was called a civil ceremony at Taunton. It's not a church ceremony. And after a week's honeymoon, he and his battalion were shipped over to the continent. And she didn't see him again, of course, until after the war was ended. But she very much wanted to marry him before they shipped out in case he didn't come back. So he did. And of course, it took a long time to get all the troops home, just like it had been taking a long time to get them wherever they were going. His battalion was shipped back over to the States in February of 1946. But she, along with the other many war brides, had to wait. And it was in June of 1946 that she was able to ship over on the Queen Mary, which was actually still fitted out as a troop ship at that time. But she came with 5,000 war brides on the Queen Mary.
But she wasn't alone.
She was by no means alone. I was 7 months along. So you might say that was my first trip on the Queen Mary. Anyway, she and I arrived in New York in June of 1946. And she traveled to Oklahoma by train. And for a little while, they lived in actually his mother's home in Chickasha. And then in 1949, he actually finished college on the GI Bill at the University of Oklahoma. He didn't yet have his engineering degree, but he got it there through the GI Bill. And then the three of us, my mother, he and I, moved to the Dallas area where he wanted to establish. He thought that was going to be a big growth area in the decades to come, which of course it has been.
I want to just jump back before we get too far away from the London Blitz.
Yeah.
And from Baghdad, and ask about another experience your mother had with bombing in more recent years.
You mean the bombing during the Blitz?
No, during the first Gulf War.
During the first Gulf War, I wasn't there. I, of course, was in Nashville then, but my sister, who still lived there, not with her, but close to her, in actually Garland, Texas, said that during the first Gulf War, when there would be nightly television views of Baghdad, and of course, precision bombing was already going on at that time. There were two turquoise blue mosque domes that were very prominent on the Baghdad skyline, and still are today. And every night she would sit in front of the TV and pray that those domes that she remembered from childhood would not get destroyed in the bombing. Well, of course they didn't, because the US was very, very careful to avoid hitting those mosques. That would have been politically very, very bad. So they didn't hit them, but she was always worried that those mosques would get hit and those beautiful domes would disappear. She was very happy when the war ended and they were still intact.
So now let's jump back to Richardson, Texas, where I guess is where she was watching TV as well. But in the early years, and so you were in elementary school and high school there.
Well, actually, not Richardson at first. When we first moved to the Dallas area, we were in Irving, which is another suburb of Dallas. And then from there, we had a 2-year interlude in Richmond, Virginia. And I attended first and second grade in Richmond. My dad at the time had a job which took him to Iceland, much at that time, with a company that was the architectural firm for one of those great big NORAD bases that were at that time being built all across the top of the Northern Hemisphere. as a, in the Cold War. So we were in Richmond those 2 years, and then when we moved back to Texas, that's when we moved to Richardson,
Which is
Which
where
is-
you
which
went to grade school.
starting in third grade.
Yeah. Now, there's an activity that you started there in grade school and in high school that you've continued all your life. And talk about that a little bit.
Well, you're talking about my horn playing.
Yeah.
Texas then, I don't know about now, but then was swimming in oil money. And that trickled down to the schools, the public schools, which had lots of money for music activities. And they started students in 5th grade in band. So I was interested and I started band in 5th grade playing cornet, which is sort of first cousin to the trumpet. Today, most bands use trumpets, but back then, most of them used cornets. So I played cornet until 10th grade high school. And our 10th grade high school had a very good band, but the horn section had almost all graduated. They only had 1 or 2 horns left. And so 3 of us switched from cornet to horn to try to create a new horn section. And I found I liked it very much and continued playing it. I played it through college in every organization that I could in college. And I still play it today.
And I believe that's with the Rebecca Symphony Orchestra.
Rebecca Symphony Orchestra. I am inactive in it now because of COVID-19.
Yeah.
My wife and I have very young grandchildren here in Davidson County that cannot yet be vaccinated. And I feel it's an unacceptable risk for them, for me to participate in orchestra right now. So I am kind of suspended, in the meantime.
Yeah. Now, you went to college at Austin College, Sherman, Texas.
Correct.
So then how did you get to Nashville? It was not to advance your music career, was it?
No, of course not. It was to go to law school. I decided midway through college that I was going to go to law school. I had no idea why. No one in my family had been a lawyer, and I didn't know any lawyers. But it just seemed like an interesting thing to do. And I knew I liked to argue, and everybody knows that lawyers argue. So I thought, well, I got a leg up on that anyway to start.
Then why Vanderbilt?
Actually, a recruiter from Vanderbilt, one of the junior faculty members, was going around to various colleges, and one came to Austin College. And I talked with him, and I was interested in what he said. So I actually flew to Nashville in the winter of 1967, 68, during my senior year, and liked what I saw here at Vanderbilt. And so I applied and was admitted. And that's how I got to Vanderbilt.
Now, among your professors, who would you say was the most influential for you?
Paul Hartman, with the nickname Dutch. I imagine most folks watching this don't remember him, but that was quite a long time ago. He's been dead for many years. But I learned a great deal from him. I just seemed to be on his wavelength from the start. He was a very Socratic professor. If anyone remembers that movie, what's it called? The Graduate. No, not The Graduate. The Paper Chase. The Paper Chase.
Your memory is better than mine.
That professor in The Paper Chase was kind of the epitome of Paul Hartman, really, in mannerism and teaching method. In fact, they could almost be doubles. Anyway, he was influential on me for several reasons. Although I know he wasn't always the most popular professor in the school.
Then in your second year, you started an activity that was a great influence on your life.
I assume it was, well, I'm not sure what you're
Clinic.
Clinic, yes. Clinic was a turning point. I didn't know it yet, but I enrolled in the clinic program at Vanderbilt Law for my second year. And I was assigned to work at Legal Services of Nashville at its original location on the 6th floor of the Stallman Building. It had opened there in the beginning of 1969. So it had been open about 8 months when I started clinic work there. And enjoyed it very much, found it extremely interesting. And so when that school year ended, I applied for and got a clerking position with Old Legal Services Nashville. And that was when I started drawing a paycheck from Legal Services. Then soon after, we opened our old South Nashville branch on 17th Avenue South. And my first job there, along with 2 or 3 other people's, was to paint the office, which badly needed it. It was an old, pretty rundown house. It had one of those multi-story back porches, you know, three floor back porches. We didn't dare go out on it because it didn't look or feel like it would support us. And so we kept that door locked. So that fire exit was blocked. The whole time we were there.
That old house is gone now.
Oh, it's long gone.
It's
Yeah,
now SunTrust Bank,
Right.
soon to be Truist Bank.
Yeah, it's long gone.
Yeah.
But it served its purpose for us.
Yeah.
And we were there for a few years.
Now,
And-
during the time when you were a paid student, what kinds of cases would you handle? What would you do?
Well, I would handle every kind of case that we did, and that was just about everything that wasn't a traditional fee case in the civil area. And it included a lot of domestic relations, a lot of collection defenses, a lot of landlord-tenant work, a fair amount of social services work, benefits work, Social Security, SSI, you name it.
And these were cases you handled as a student.
Well, yes, under supervision, at least officially. Yes,
But you were certified by the Supreme Court. You were one of
in 1970, and this is, of course, when I still had a year to go in law school. I was in the original group of certified law students, certified under the limited practice rule that was new then, that had been handed down by the state Supreme Court. And there were 3 of us in that group. So yes, I was one of the 3 original students certified for limited practice.
Now, so after you graduated, you then were offered a job or asked for a job, or how did that happen? Tell about the hiring process.
Well, it wasn't a very complicated process. Our director at the time was an older man named John Corbett. And it was in the spring of my last semester in school. So Mr. Corbett said to me one day, "David, would you like to work here after you get a license?" And I said, "Well, yes, I would." He said, "Well, good, you're hired."
So that was the process.
That was the hiring process in 1970, yes. Sort of embarrassed to admit it today, but it wasn't hard to get hired. If you were liked and your work was known, it wasn't hard.
Well, you had some experience.
I had some experience, yes.
And the office then, that office was still at the Stallman Building, so you worked there for a while.
Correct.
And then where did you go?
Well, we had an office for a while, not long, at what was called the Sutica Building. It's no longer there. I guess 2 years at the Sutica Building. But I also was working at what was then our North Nashville branch. We had opened a branch office in what was then the Matthew Walker Health Center at 16th and Herman Streets, the north side of the tracks, right between 2 big housing projects, John Henry Hale and Andrew Jackson. And I worked there for about 3 years. And after 1 year of licensure, I was licensed in September '71. And after a year, I became the managing attorney of that office, there being no one senior to take the job. Uh,
But
yeah,
in that first year, though, you were involved in some pretty high profile
well,
federal cases.
and I need to explain that. We did a fair amount of civil rights work then. Mostly cases under 1983, 42 U.S. Code 1983. And we sued various entities. The first case I was involved in was brought in December of 71.
This is 2 months after you were licensed.
Or three months. And of course, I'd gotten my district court admission. I was actually getting it as this case began. We sued all of the Metropolitan General Sessions judges. And I have to give just a little bit of history here. The old city and county governments merged to become Metro in 1963. And that created the problem of what do you do with the courts? Because we had the old city courts and we had the old General Sessions courts. They were merged to become the new Metropolitan General Sessions Court, which it still is. At the time that I started practice, it had 9 divisions, 9 judges. Data has 12, which aren't enough, but that's what it has. And one of those judges had been on the old city bench, the old Nashville City Court bench since 1946, and his name was Andrew Doyle. Doyle was very interesting. He would not participate in the rotating dockets that all of the other judges agreed to do. He said, I'm going to continue to do my old city court metro ordinance docket every day, and I'm going to do it at 8 a.m. in the morning. Everyone said, okay, it's yours. So he did it. Well, one of the metro ordinances that was constitutionally questionable at the time was the one that required that if you were convicted on a metro ordinance violation, whatever it was, and you couldn't pay the fine and costs immediately upon conviction, and most people of low income couldn't, you were sent to the workhouse to work off your fine and costs at $5 a day. Well, we were aware of the constitutional problems with this. There had been a case a few years before out of the Supreme Court, which was very similar to this situation. We acquired a client, Mr. Harding, who had written quite a few checks which had bounced. And Judge Doyle had actually convicted him on all of them at one time. There were about 8 or 9 of them. And his fine, of course, was $50 each, and the costs exceeded the fines. They did then as they do now. And Judge Doyle sent him to the workhouse. He became our client in the case known as Harding versus Doyle. We actually named individually all of the judges of the Metropolitan General Sessions Court, but we gave Judge Doyle the honor of being the first named defendant, so the case was Harding versus Doyle. And of course, it was in federal court. The case settled very quickly. Before the end of December, we had hammered out a settlement agreement with Metro, which incorporated in it a protocol for the court system, giving every defendant who is convicted a chance to show his financial status and be put on a payment plan. And only if the defendant violated the payment plan could he be incarcerated on that ground. And that protocol is still in effect today. It's, I understand, had some modifications in how it's put into effect, how it's done, but it's still in effect today, and that is when it began with Harding versus Doyle at the end of 1971. The following month, we had a little interlude where one of the judges intentionally refused to follow it. That person, having been incarcerated, was referred to us, and we took up her cause, and we drew up papers for contempt and for temporary injunction. The judge whose case it was, who was Judge L. Clure Morton, was on vacation out of the country. So Judge Frank Gray, who was actually the chief district judge, there were only two federal judges here in Nashville, and Judge Frank Gray dealt with it, and he dealt with it when it was filed, by summoning us and Metro to his home in Franklin, where he lived, for the hearing on both our contempt and our injunction request.
This was a rather imposing home.
It was one of those very stately homes on Lewisburg Pike in Franklin. If people are at all familiar with Franklin, an old home. Judge Gray was from one of the old families, well-to-do families of Williamson County. So we went to his home, and he took us into his library, which was about 2-3 times as big as this room we're in, and sat us down. He had us check out the file from the clerk's office before we came, so we brought the file with us. Of course, it was all on paper then. It was none of this online file stuff that we have today. So we brought the file from the clerk's office, and he read the file. One of the Metro attorneys that brought the judge who had violated the order, brought him out. And so we were all sitting in Judge Gray's library while he read all the papers. And then he put them down, and he said, well, I've read everything. And
Now, it's worth mentioning, Judge Gray could be pretty fiery at times.
Judge Gray could be very fiery. Judge Gray stood at the most 5'4". And I think every law enforcement officer within his jurisdiction was terrified of him. He had an awesome reputation. Nobody wanted to mess with Judge Gray. So he read all of the papers, and he laid them down, and he looked directly at the offending judge and said, well, Judge, I've read everything. What do you have to say? And, the judge looked down at his feet and mumbled, said, nothing, Your Honor. So Judge Gray said, well, I'm going to issue the injunction. So he signed it, and he called the clerk's office to tell them the exact time that the injunction had been issued. And he said, as far as the contempt petition, since this is Judge Morton's case, I'm going to leave the contempt matter for Judge Morton to deal with once he's back, and we'll keep it in abeyance for the time being. So that's what happened. It was kept in abeyance, which was fine with us.
Now, this was a case that you handled with Paul and Rita Geyer.
Right.
Is that right? While they were here. And I believe that the person who then got to deliver the order to the jail was Walt Kurtz.
I believe that is correct, yes.
Because he had been on intake when the client's mother
He had indeed.
had come in to say her daughter was in jail.
And I believe he had actually drawn up the contempt petition that we took with us. Yeah. Correct.
Well, now Paul and Rita then left soon after.
Right.
Well, within the year.
Mhm.
And at that point, you were sort of the senior federal litigator.
It's hard to believe. Yes.
In our organization. And the one case that I remembered that was sort of interesting was the Kadali case involving a residency requirement.
Kadali versus Briley. That would have been, of course, Beverly Briley, the mayor at that time. Yeah, that had to do with durational residency for being eligible for admission to the hospital, Metro Hospital. Veronica Dolly was an Indian immigrant who had arrived pregnant. Her sponsor, financial sponsor, who was actually a relative, had withdrawn his sponsorship after she arrived in the country and left her financially high and dry. There was at that time a durational residency requirement. You had to have been a resident of the county for, I believe it was a year or 2 years. I think it was a year, which of course she hadn't been. And they would not, she was almost due to deliver her baby, and they would not admit her for delivery because she didn't meet the residency requirement.
And she couldn't pay.
And she couldn't pay, right. So we brought a 1983 action against Metro challenging the durational residency requirement. And that was soon resolved by agreement. And they dropped that residency requirement. And we cleared the way for admission to the hospital. And then after that big rush to get the case filed, and Judge Morton had that case too, and he did issue a temporary restraining order. So we didn't have to have a hearing on that.
Yeah.
But before that had expired, they had agreed to drop the residency requirement. And then after all of that, she was late with her baby. It was 2 or 3 weeks late coming.
But she got to deliver the baby.
She got to deliver the baby.
Meharry
Oh,
Hospital.
yeah, at Meharry, correct.
That's okay. Now I'm going to interrupt the discussion about cases to ask you about an important event in January of 1973. So we had a little bit of personal history before, and now just another piece of that.
Well, you'd be referring, I assume, to my marriage.
Yes.
To Sarah.
Yeah.
Yes, the main thing I remember about that was that I was dispatched at the last minute from the church to my house to get the napkins for the event, which of course I had forgotten to bring. It was a snowy day. It was in January, and I got the napkins, and on my way back into the church, I fell headlong into the snow. So I went into the church covered with snow for my wedding. Managed to get most of it brushed off.
But the marriage happened.
The marriage happened.
To Sarah Binkley.
Sarah Binkley, who became Sarah Binkley Tarpley.
Okay. And you now have how many children?
6.
6 children. And their ages range?
Their ages range from 33 to 47.
Okay. And grandchildren, how many?
We have 8 and counting, because number 9 is due to arrive in about 10 days.
Okay. Now, back to the cases. At one point early on, you began specializing in consumer law.
Mhm.
Tell about how that happened.
Well, that was in 1974.
Yeah.
We had been operating, of course, for a few years, with everyone doing everything. And we realized that there were so many folks needing help who qualified for our help, and so few of us, that we could probably give better service if we started concentrating in specific areas where we could learn more about that area and become more proficient in it. I hesitate to call it specialization because, for the most part, with the exception of domestic relations, they weren't areas that you officially specialize in law. You can't get, any sort of certification for specialty, for example, in consumer law. But we started specializing. And to do that, we formed case handling sections, as we call them. And we knew that one of them needed to be consumer protection. By that time, I had developed quite an attachment for the subject. I really liked it. No one else was interested in it, so I staked it out quickly and became the
Much to our relief, the other people.
Much to everyone's relief, yes. much to everyone's relief. And for a while, I was the consumer section along with what we call them then a secretary. After about a year, I acquired a very capable young assistant who was with us for 2, maybe 3 years. That was Sean Edmund. But at first the section was just me doing consumer protection work.
Now,
And I've never stopped.
you've been at it since 1974.
Right.
Consumer law. Well, let's talk about some of the cases that you handled along the way. I mean, there are thousands of them, but some of the more remarkable. Start with probably the most dicey one, at least that I'm familiar with, your season sash case.
Yeah, actually 18 cases. Season Sash was the collective name for a trio of Kentucky corporations based in Lexington, Kentucky, that was operating in several states, including both Tennessee and Kentucky. What they did was they manufactured and retailed replacement doors and windows in residences. As I said, there were 3 corporations. One of them did the manufacturing, one of them did the retailing. The third one did financing. They did not finance all of the season sash transactions, but they handled a good many of them. The rest were financed through banks that purchased the contracts and deeds of trust that Season Sash had generated through its sales. But these corporations were all owned by the same individual living in Kentucky, who was an ex-con at the time with a federal prison history for an unusual crime, federal truth in lending violations. I don't see many of those, but he was one of those. Anyway, this company had a very interesting MO. They attracted customers through various means, mail flyers, direct mailings, putting notices on doors and screens, leaving them in mailboxes, various ways of attracting attention. And they would simply say, call us and we will come out and pay you a visit and show you what we can do for you, no obligation. And many people called. Well, their MO, as we learned both through discovery and through unofficial sources, was that they would always call and set up an evening appointment with the household. They would try for 6 p.m. if they could get it, because they knew that most families would be wanting to put dinner on the table soon. And this was all in their training materials, very explicit. They would come and start their pitch. They'd have samples and like pretty graphics and things. And they were watched. There were people stationed close by, outside, of course, in cars watching. If they stayed in the house less than 4 hours without getting a sale, they were penalized on their salary. People signed because they were desperate to get them out of the house. A few people signed because they were physically afraid of them. They were so overbearing. It was an incredibly hard pitch sale. Anyway, we ended up over a period of about 1.5 years of acquiring clients with 18 different households as clients. Now, these ranged from households of just one person to 2 parents and several kids.
Well, now you mentioned your unofficial discovery of their operation. Tell about that contact.
Well, we had filed 2 or 3 of the cases already, and we were looking around. They had briefly operated a sales office in Nashville. It was only open a few months and then closed, and they continued their operations through their Knoxville office in Nashville. But I had the name of the fellow who had been their Nashville office manager before they closed. And I've been asking around to see if anybody knew where I could locate him, to see if he would talk with me. I got a call from him one day out of the blue. And he said, Mr. Tarpley, I understand you've been looking for me. And I said, I have. Thanks for calling. I'd sure like to talk to you. He said, I could talk to you, I will, but nobody can know that you and I have talked. I said, okay, well, he said, I can't come to your office. I can't do that. I said, well, then what do you have in mind? And people couldn't believe this when I said it, but he said he named one of the big office buildings out on Elm Hill Pike, not far from the airport. And he said, it has a big parking lot. If you can come around 6 p.m. in the evening, I'll be parked in the very back of the lot. It'll be empty. I said, okay, that's where we're going to meet. He said, yes, and please come along. So I did. People in the office later said I was crazy for doing that, but I did. I went, and sure enough, when I pulled into the parking lot, here's this one car in the very back and a fellow standing beside it. So I went up to him and said, are you so-and-so? He said, yes. And you're Mr. Tarpley? And I said, yes. He said, nobody can ever know I talked to you, because if they find out, I'm a dead man. I said, oh, that's pretty dramatic. He said, oh, yeah, I am. I said, well, why would that be? He said, because you're dealing with the mob. So I said, okay, well, are you willing to talk to me? He said, yes. Well, he ended up giving me a lot of information about the operation from the inside, including who were the top people, and a lot of about their MO, how they brought their supplies in from Florida in trucks, and how they were trained, how the salesmen were trained, a lot of things. I swore to him that his identity would never be revealed by me, and it wasn't. However, I did use the information that he gave me as leads for developing discovery, which we did.
And then you took depositions of.
Yeah, we got to the point where we needed the depositions of the top man who owned all the corporations and his two chief deputies. So we scheduled those. By this time, we had at least a dozen cases pending, mostly in federal court. We filed in federal court. I'll get to that in a minute as to why, but we had a common federal question. So we gave notice that we were deposing the top man and his two chief lieutenants. And they were flown in on a private jet from Cincinnati, or Covington, which is right across the river, Cincinnati, I'm not sure which. Anyway, they flew into Nashville for their depositions and came to the office. The office at that time, our office at that time was in Parkway Towers. So they walked in, and I swear I thought that we were looking at the cast of The Sopranos. The top guy was one of the biggest men I've ever seen. He was about 6'7". He had to weigh at least 300 pounds. And his two lieutenants weren't much smaller than that. They all had huge bulging necks. I mean, it was really something to see them. So we deposed them. I deposed the top man, and Drake Holliday, an attorney with us at the time, deposed the other two. And they played ring around the rosy with us all day, tried to dodge questions and not answer them. And we kept hammering them to get the information we wanted. And it was basically successful. We got the main things we wanted. But that was our day deposing the top man in the Season Sash trio. Well, the next thing that happened of note, we ended up with 18 households as clients. We filed suit for all of them. Whenever Season Sash's in-house financer had done the financing, of course. We included that corporation as a defendant. When the ones that had been financed by outside banks, we sued those banks in the suits. The common issue which gave us federal jurisdiction was an embedded violation of truth in lending, which they were committing in all of their contracts, every one. I'm not going to go into detail about it, but it had to do with a false overstating of how much they were paying out for title searches on each of those properties. They said they were they said they were paying out $100, which they weren't. Most of their title searches, the ones that were local, they were getting on a volume discount from somebody at $45 each. The ones from out of county were a little more, but none of them approached $100. Remember, this was back in the 80s, 1980s. But that gave us federal jurisdiction. And that's why we were in federal court most of the time. We only filed one state court case just for variety, and it settled quickly too. Anyway, they filed bankruptcy. We got notice with all of these cases pending. We got notice that they had filed Chapter 11s in bankruptcy court in Lexington, Kentucky. So I got admitted to the federal court in the Eastern District of Kentucky so that I could go and scrap with them there in the bankruptcy court, which I did. I think I made 3 trips total to Lexington for that purpose. And of course, we filed claims for our clients in the bankruptcy. Anyway, the corporation's dissolved. And the main creditor that I think really took a loss was Fifth Third Bank out of Cincinnati, which had put up most of their floor plan financing. So they were a big secured creditor, and I don't think they ever recovered anything. But the corporations disappeared, and that left us only with dealing with the cases where the assignee banks had purchased the contracts, and they were all wrapped up with settlements, actually. The bottom line of all that was, out of the 18 households that we took as clients, not one of them paid one dime on their accounts with Season Sash after the day they became our clients, and all of them got their deeds of trust released.
You were unable to recover anything they had paid, but
There was nothing to
there's
recover.
not, I mean, the secured creditors came in ahead of you.
Right.
Yeah. Well, and everybody survived. You and Drake survived intact.
Okay, there was one other, about their being connected with the mob. Several months after we had deposed the head guy and his subordinates, I got a call from a criminal investigator with the Kentucky Attorney General's office. We had been working sort of hand in hand with both the Kentucky and the Tennessee AGs, who were also after Season Sash. And a criminal investigator from Kentucky called me and said, "I thought you might want to know who you're dealing with." And I said, "Well, I got a feeling I know what you're going to say, but go ahead and say it." He said, "You are dealing with the mob." I said, "Well, why am I not surprised? I've heard that before." And he gave me some more detail on how that was, just what they were actually doing. It was a criminal enterprise. So
Go ahead.
I thought, well, this is interesting. On the day that that happened, several of our attorneys were in our conference room doing what we call case acceptance, going over new intakes together. I thought, I'm going to see what happens here. So I walked in to case acceptance, and I said to the group, "Hey guys, guess what? The Season Sash cases." And everybody said, "Yeah, what about them?" I said, "Y'all might want to know we're litigating with the mob," because I wanted to see the reactions. And it was great. For about 3 minutes, nobody moved. Nobody said a thing. But you could see the wheels turning in everybody's minds. I think people were trying to calculate the distance from their office to mine. So that if it was just a small bomb, maybe they would survive. Anyway, yeah.
Okay. little less dramatic, but collection agencies were a big part, have been a big part of your life. Particularly, one memorable case was involved one from Lebanon, Tennessee.
Yeah, and that was actually, from our standpoint, 5 different suits that we filed, all in federal court under the Fair Debt Collection Practices Act, against this same rogue collection agency that was operating in Lebanon. And I couldn't even name all the violations they were doing routinely every day. Some of them in litigation, they were filing suits themselves in their own name as a collection agency, even though they hadn't purchased the accounts and didn't own them. It was just a rogues gallery of violations they were doing.
And the person who ran this was collecting attorney's fees, even though she was not an attorney.
And many of the accounts that she was assessing and collecting attorney's fees on didn't even carry attorney fees. Medical accounts, for example. It was awful. I mean, it was just incredible. And she was getting away with it. No one in Lebanon was challenging it, except one person knew that it was a lot of illegal. Well, a lot of it was illegal. He called me and said, look, we've got all kinds of stuff going on here. I don't know exactly what all the laws are that are being violated, but I know there are a lot of them. I said, what you need to do is refer some of those victims to us so that we can qualify them, they can become our clients. So he did. And because Wilson County was in our Gallatin office service area, they were referred to Gallatin, and the intakes were done there. And they were sent to me. When I read them, I called the Gallatin staff. I said, you guys are pulling my leg. This stuff is not real. You've made it up. No, we haven't. This is what these folks say happened. Okay, so I interviewed them, and we brought 3 cases fairly quickly together. And then while they were pending, we acquired 2 more households as clients, and we brought those suits as well. Eventually, all the cases were settled. The company's errors and omissions policy applied, and their attorneys, the attorneys hired by the E&O carrier, defended the woman who owned the company. It was, in fact, a one-woman company with a few assistants. And we mediated. They were all in federal court, and we actually mediated in front of a neutral district judge who, of course, did not have the case. And the mediations were successful, very successful. It wound up that all of our clients got nice damage awards under the FDCPA. We cleaned out her E&O policy limit. There was nothing left in the policy. And we got an injunction under the injunctive provisions of the Tennessee Consumer Protection Act. And it was a multi-part injunction. It listed about a dozen different violations that the company had been doing routinely, and enjoined the company permanently from doing those any further. That sort of stretched the limits, I think, of the court's jurisdiction under the injunctive provisions of the TCPA, but it was valid.
The TCPA,
Tennessee Consumer Protection Act, which was our vehicle for the injunctive relief. We had also actually, in that case, brought suit under civil RICO, federal civil RICO.
Federal Civil RICO.
Racketeering, Influenced, and Corrupt Organizations Act, what are called the unlawful debt provisions of that. Because she was charging without any authorization whatsoever, a so-called interest rate up in the 20s. And that certainly qualified it as an unlawful debt under RICO. So
now, when you finished with that case, you weren't really finished.
Oh, it wasn't. Those cases all wound up, as I said, with nice settlements, and our clients were quite happy. But she was still operating her agency until I got a call one day from an attorney who he was a state employee. He was assigned to work with the Tennessee Collection Service Board.
Which,
Well, I have to explain. Tennessee is one of the states that requires that collection agencies to be licensed. And the Collection Service Board, of course, is the agency which issues and enforces those licenses. So he called me one day and said, well, we have this administrative proceeding pending to revoke that agency's license based upon your cases. I said, oh, I'm glad to hear that. I think it needs doing. And I know my clients will be very happy to come testify. He said, oh, I'm sure they will, yeah. But that's not why I'm calling you. And I began to get a kind of a cold feeling in my toes. And I said, why are you calling me? Well, I'd like your help. I said, well, the problem is I'm not a state employee. And I don't know if I can help you with that. Certainly not on the legal aid payroll, because I wouldn't be working for legal aid to be working for the state. He said, oh, I can fix that. I said, how can you fix that? He said, I can subpoena you. I said, you wouldn't. He said, watch me. And he did. A few days later, here came my subpoena to attend the proceeding for revocation of this agency's license in front of the 5-member Collection Service Board. And it was set about 3 weeks away. So, of course, I had no choice. I went. And all my clients were there. They were overjoyed to see me. It was kind of like a happy family reunion by talking to my clients. But I still didn't know why I was there. I did not know why I was there. I assumed that maybe he wanted some help while he presented the state's cases. Well, it started and the board was all seated there at the table. And he stood up and he introduced himself and he introduced me. And then he said, now, Mr. Tarpley will present the state's case. And he sat down. I was still standing there, I'd just been introduced. Here are the 5 board members looking at me, looking at them, I smiled, like it's just every day. But I was pretty seething inside. Now, he had all of the paperwork from all of the cases. They had gotten the entire record from district court, all of the cases that was sitting there all in order. And of course, it was all pretty fresh in my mind. I knew all the cases. That wasn't the problem. But anyway, having no choice, I started calling my clients as witnesses one by one. And they all told their stories, and we introduced documents from the court record as appropriate. And that took about 3-4 hours to get all of that done, for all of them to testify. And she, the owner of the company, had an attorney, although he really didn't have much to work with. But he cross-examined them. And then they presented a short defense. And by then it was the end of the day. So we adjourned for the evening. We were told to come back the next day. So we did. Went back and the board went into executive session, which of course means we were all shooed out of the room, had to wait until the board was finished. And when they finished, they called us back in and they revoked the agency's license. And they issued a pretty stiff administrative fine, which went to the state, of course, not to us, but to the state. And that did put her out of business. She never went into business again. It stands, as far as I know, still today as the only state administrative proceeding where a collection agency's license was revoked solely because of its treatment of debtors. Now, there have been others where their licenses were revoked, but it was all where they had stolen money from their clients, the creditors. They cooked the books and, not reported all their income, things like that.
Mhm.
But as far as I know, this is the only administrative proceeding where an agency's license is revoked solely because of the way it treated debtors.
Yeah.
That was the story of the 5 collective cases against Mid-10 Adjustment Service, as it was called.
11 Tennessee. Now, a little closer into Nashville, Consumer Lease Network, at least it has statewide implication, but it started here.
Consumer Lease Network was a rather ingenious company. My hat was off to the man who first put it together. I learned through discovery he had been the regional manager of one of the big nationwide collection agencies where he, I think, learned the trade. Consumer Lease Network was a company that did financing, subprime financing for retail vendors of furniture and appliances. And they had arrangements with quite a few of the companies in Nashville that sold furniture and appliances, including some of the old companies that some of us old timers remember down on Lower Broad, when there were companies down there that sold furniture and appliances.
Very different from what Lower Broad is today.
Oh, no resemblance at all to present Lower Broad, no. Anyway, when the companies that were selling their products had customers that would not qualify for their conventional financing means, which were usually just through finance companies that would purchase the accounts. They had an arrangement with the Consumer Lease Network in which they would have the customers sign paperwork for what amounted to consumer leases under the then fairly new Federal Consumer Lease Act. And they were well drawn. I had to say they were well done. But the customers didn't seem to know what they were signing. They thought they were just buying the merchandise on credit like everyone else. They didn't know what was in that paperwork. Well, in fact, what was in the paperwork was not only was the total of payments on lease payments, of course, very, very high, but there was a residual payment clause in there that was kind of hard to spot, under which they still owed several hundred more after they finished all of their installment lease payments. None of them knew that. In fact, when we deposed the salespeople from the stores, the salespeople didn't even know that those provisions were in those contracts. They were unaware of it. Well, we had 2 clients who had purchased appliances from one of these stores and had no idea what they were doing. They didn't receive any paperwork at all until the appliances were delivered to their homes. They didn't get them in the store when they were supposed to. They both got them when they were delivered to their homes. So when they realized what they were into and that they were paying roughly 3 times the actual retail value of these appliances to buy them, they consulted us, and I looked at the financing stuff and realized that there was a viable case here, and it could be argued either of 2 ways. Either that these were disguised installment sales, or that they were disguised loans secured by the appliances. It could go either way. You could argue it either way. Either way, they violated the law. Several laws. And so when I drew up the suit, I couldn't decide which way to go. So I decided to plead them in the alternative, and I pled both theories. These were chancery suits. They went to Chancellor Bob Brandt's court. And I know some of us remember when Bob Brandt was on the chancery bench. They wouldn't settle, and we tried the cases. And after a while, Chancellor Brandt issued his ruling. His ruling was that these were disguised installment sales, violating the Tennessee Retail Installment Sales Act and also the Federal Truth in Lending Act. And they carried statutory penalties, fines, which went to our clients. Of course, our clients kept the items. They were using the appliances they bought. They kept those. But more importantly, maybe, the company did not appeal Chancellor Brandt's ruling. Instead, it ceased doing business in Tennessee. It was doing business in about 7 states, Tennessee and surrounding states. But it left Tennessee altogether after Chancellor Brandt's ruling. They decided they were not going to, I guess, take their chances in the appellate courts. So that was the end of the CLN, the Consumer Lease Network cases.
Now, you had quite a number of home repair cases over the years.
Yeah.
And again, it was a matter of the failure to comply with truth in lending and other.
About 3/4 of the cases, the home repair cases that we had, and we're talking about maybe between 40 and 50 cases. And Poole did a great big volume in home improvements, mostly in North Nashville, some in East Nashville. And Poole had interesting ways of operating. He had an acquaintance named John Nanny who set up his transactions a lot. Poole did, of course, most of Poole's clients could not pay cash. They had to do credit. So he set them up on installment sale contracts secured by deeds of trust on their residences. Mr. Poole did not understand truth in lending. And we brought many cases against Mr. Poole for different violations of truth in lending and various other things, shoddy work, incomplete work, some cases of outright fraud. We had several where he would do a contract for siding with sheet insulation underneath the siding. When you pulled up after the job was completed, if you pulled the siding back, there was no insulation, that kind of problem. But we had many cases with Poole. That's who that was our main defendant. Although there were others, but he was by far the biggest offender.
Now, also one other case I would like you to talk about is the consumer strike that, the Cosmopolitan Health Spa cases.
Cosmopolitan Health Spa. This was back when health spas were a big deal in new businesses, starting really starting around the early 70s. Cosmopolitan Spa was owned by a gentleman named Seth Smith, who lived in Williamson County. And it turned, before it was over, it was a chain of spas in Nashville and surrounding communities. Eventually, it all went bust, but for quite a long time, Cosmopolitan Spa outlets were being built, financed largely through pre-sold contracts with consumers, and then assigned to banks as collateral for financing in order to build the spas. It was sort of an operation built on its own coattails. I know they operated, it was at least 4 spas at Nashville at one time. This was in the late 70s and 80s. And there was little regulation of health spas at the time. I think it was a result of excesses by Cosmopolitan and some other spa operators that resulted in tightening of the statutes that regulate health spas. But what Cosmopolitan liked to do, and did a lot, was to pre-sell lifetime memberships. And bear in mind, this was often in a spa that hadn't been built yet. But it was going to be, and it was going to be great. And people would sign up for lifetime memberships. They'd pay an advance fee, and they assessed a monthly fee for 2 years, maybe 3. And then after that, they would owe just an annual fee for life. That was the idea. Well, we had a lot of those cases because, the way life goes for folks, they would sign up. Some never went, assuming the spa was built. Some would go for a little while and then quit. Had a baby, had a divorce, whatever, life changed. Stuff happens when they quit going. But Cosmopolitan would bring suit on all of them eventually. And the law firm that brought most of Cosmopolitan's collection suits was the old firm of Buffalo, Ziegler, and Lowenstein that was at the time in the old Third National Bank building at 4th and Commerce. And Herman Lowenstein handled the majority of those collection suits in General Sessions. So Herman and I got to know each other quite well pretty early. I never kept count, but the best estimate I can give now is we probably had between 40 and 50 collection suits in sessions. Well, we didn't try them for the most part. There was no need. It got to the point where when I would call up Herman and to say, well, we've got another Cosmopolitan client, he would want to know who it was. And after he found out who it was, he would just not suit. So
You'd say it's gone.
It's gone, right. Now, there was a point where we actually put several of them together. We took several up on appeal to circuit court. We consolidated, and we actually filed a suit for declaratory judgment, seeking a ruling that their collection tactics, suing for the full extended time balance on contracts, which terminated very early with no more obligation on the part of the spa, amounted to a forfeiture on the contract, an excessive forfeiture, therefore uncollectible. We never got to the point of arguing that because it was settled, but we did go far enough to at least plead that in circuit court. And we were ready to have it heard, but the case settled. But no, Herman wanted to make sure that we didn't try any of those cases in General Sessions Court.
Now, with the introduction of Herman, I think it's worth noting that later on, Herman Lowenstein made a very generous legacy gift to bequest to the Legal Aid Society. And in significant part, because of his respect for you and the relationship that the two of you formed over the years in many, many cases, not only Feldspar, but others as well. The other person who made a large bequest, he and his wife, Bill McHugh, you also had, I mean, the common denominator for the two large bequests to this point to Legal Aid Society have been that there were people who mainly had cases against you.
Well, Bill McHugh, we had a lot of cases with Bill because he had a lock on the GMAC collections work. That was, of course, the old General Motors Acceptance Corporation, which goes by a different name today, but it still exists. But he had the lock on their collections work all through Middle Tennessee, including, of course, Davidson County. And so we had a lot of GMAC collections cases with Bill. And yeah, what you're saying is basically correct.
Yeah. Just, I think, a testimony to collegiality in the bar and the respect that y'all had for each other. A little closer to this time, recently you've had a number of foreclosure rescue cases.
Yeah, sad to say, the main increase that I've seen in terms of the volume of our work in the past decade has been fighting foreclosure rescue scams. And generically speaking, these are cases in which people have gotten in trouble on mortgages, which they couldn't pay for whatever reason, lots of reasons. They hadn't yet been foreclosed, but they were then maybe just worried about foreclosure. In many cases, foreclosure was pending in one stage or another. In some cases, it was almost to the point of sale. But that was the common denominator, the fear or threat of foreclosure. And the scammer would come along and offer to bail out the homeowner and save the home. There are various methods of operation used for that. The most common and the one we've seen the most is what we call the sale and leaseback, where the scammer takes title to the home, perhaps with the understanding of the homeowner, sometimes not, and does a lease with an option to repurchase. The option to repurchase is always on terms that are absolutely unaffordable for the homeowner. The homeowner simply cannot meet it. So the scammer has taken title with a promise to restore the home on the purchase option, or in many cases we've seen has not even disclosed the nature of what's being signed. We have a new intake right now at the office that we're investigating, in which the correspondence between what is still our applicant, because we haven't accepted her case yet, and the scammer was done by Instagram. So we are now in process of trying to get that whole stream of Instagrams into our system so that they can be easily read and used, and if necessary, as evidence in conjunction with, of course, our client's testimony. But if those Instagrams show what she says they will show, that was in fact a rescue scam. But yeah, the common denominator on most of it is the sale and leaseback. And again, when I say sale, I mean transfer of title. Because we've had too many in which we know that the client did not know the basic nature of the instrument being signed, or instruments rather. But they're so desperate to save their home, they will sign anything they're told to that they think will save the home.
Well, David, there's been, of course, thousands of other cases that you've handled over the years. Plus, you've been a mentor to many lawyers who've been with legal aid or outside of legal aid in the area of consumer law. In addition, you had a teaching career for part of the time. You want to just tell about that?
Sure. This was at Vanderbilt Law School. As I said, I graduated in '71. In 1986, one of the professors at the legal clinic in Vanderbilt, I should preface this by saying that for those who don't know, Vanderbilt Legal Clinic has always used what we call the live case model, not the simulation model that some clinics have used, although I understand that's going out of style. But it used to be quite common for clinics to, in effect, manufacture the cases that the clients practice, like the students practice with. But Vanderbilt has always used live cases, that is, real clients with real problems. Well, in 1986, one of the professors at the clinic, Frank Block, was about to go out of the country for a year, and they needed a replacement for him in the clinic that coming academic year, which started the fall of '86. I was invited to come and do a consumer clinic, which had never been done before. Well, of course, that takes a lot of time, and we had to figure out a way that I could do that and still remain full-time. Ashley, who's, of course, joining me in this conversation, was then our executive director, and I spoke with him, and we devised a plan and proposed it to Vanderbilt. I called it a lease purchase plan. I was the subject of a lease purchase between legal aid and Vanderbilt. Vanderbilt paid a proportionate share of my total salary and benefit cost to legal aid in exchange for that percentage of my time.
Are you saying I sold you to Vanderbilt?
No, I said you leased.
Oh, sorry. Okay, I see the difference.
No, it wasn't slavery.
Okay.
It was just a lease. Anyway, I was the subject of a lend-lease to Vanderbilt for that year. The cases came right out of our regular intake at legal aid. I would screen them each week and spot the ones that I thought would look like promising teaching cases. And I would speak to the applicants and ask them if it was okay if those cases could be handled at the Vanderbilt Legal Clinic under my supervision, and they all agreed. So the students would interview those applicants at Vanderbilt. They would become both legal aid clients once they were qualified, and also Vanderbilt Clinic clients. And we'd handle the cases there. The students would handle them. I assigned them all in teams of 2 on each case. And in the cases that didn't finish when the academic year ended, I would simply bring back to the office at legal aid to finish up there, because they were already legal aid cases. It worked quite well. After 5 years, the professor who had been teaching a traditional consumer law course at Vanderbilt left, and there was no one there left to teach it. Well, I thought that would be interesting. So I presented a proposal to the curriculum committee at Vanderbilt, proposing to teach actually a variant of that, and that was consumer credit. It was accepted, and so it was put in the syllabus, and I started teaching consumer credit. And I wrote my own syllabus. I didn't rely on a textbook. I put in what I thought they most needed to learn about in the limited time we'd have for the course. But I did that until, well, I don't remember the exact what was the last year I taught it. It was around 2014, maybe 2015 was the last year I actually taught it. They quit offering it because they had switched to a limit on the number of students. I'm sorry, a minimum number of students who would have to sign up before they would offer an upper level elective through an adjunct professor. Well, by that time we were called affiliates. They didn't call us adjuncts anymore. They called us affiliates. But my class didn't make. I didn't have 10 people signed up who wanted to take it, so it was not offered. And it hasn't been offered since then, but it was a whole lot of fun during those decades that I did it. I liked it.
Good. Well, it's been quite a run, and it's been a pleasure talking with you about it this afternoon. Thank you for doing this.
You're welcome.